I'm glad to have some experts with me from Switzerland, Dominik Oberholzer. Very glad that he joined us on our panel today. And on my right, to the left of from your side, is John Verwey from Proskauer London office. I'm also very glad that he's here because the two of them will talk about the Swiss regime and the UK regime, which is always a little bit difficult to understand from someone from Germany, and it is important for most people if you would like to market fund interests in the UK or in Switzerland, where in my experience, they are kind of important marketing jurisdictions for German fund managers. So I'm glad to have them here and to explain their position. And what we want to talk about is funds regulatory law, but with a focus on MiFID. We will first give you a short introduction on the MiFID regime in Germany, in the UK, as well as the regime in Switzerland. And then we move on to a couple of topics in a funds management, funds marketing related context, so that you get a better picture of the issues. And we will touch a couple of important topics which have changed to the previous regime. And then if we still have some time, we can talk about some pet topics like Brexit, if you would like to. So let's start with a short overview of the MiFID regime. What is the MiFID regime about? The MiFID regime means, this MiFID stands for Markets in Financial Instruments Directive. It is a European law, a European directive. Actually, this MiFID regime has been in place in some kind of variation since 1994. The MiFID regime, as we know it, was then introduced in 2004. It was called it's called now MiFID I. And the MiFID I regime was entirely replaced by a regime called MiFID II. And this regime was enacted in 2018. And quite frankly, the MiFID regime worked quite well, the MiFID I regime. So I was not quite sure why it was really updated. The MiFID II regime makes things more complicated. One goal was to provide better protection for professional investors under the MiFID II regime. And that's why a lot of changes are also relevant for fund managers who market interests to institutional investors. So what is MiFID about? MiFID concerns mainly certain trading markets, which we do not talk about here, and I have no idea what this in detail is about. But it's a big part of MiFID is also the financial services regulation. Financial services means if you have an advisory mandate and you advise a client on investment products, or you introduce a client to investment products, this means it's a financial service, and this is regulated by MiFID. The same for portfolio management. If you provide individual portfolio management to a client, this is also a MiFID service, and it is regulated. And what is in there in MiFID with regard to this service? It is basically introduce organizational requirements on the firm which provides these services to the client, and it introduces kind of rules of good conduct toward the client, which means, for instance, that you have to disclose certain conflicts of interest to the client. You have to get certain information from the client to provide the client with the, let's say like this, the perfect investment advice. You have to get information from the client so that you can be sure that the client understands the instrument, the financial instruments that you are selling to the client. So this is all kind of obligations in MiFID, and we mainly concern placement agents, advisors, introducers to financial instruments. MiFID does not directly concern fund managers. If a fund managers would like to market the funds to someone else, it's not MiFID relevant in the first place. But since this MiFID II regime, a couple of things have indirectly become relevant also for fund managers. In particular, if you would like to appoint a placement agent. But we will talk to this a little bit later on. So the MiFID regime is implemented in Germany in the Securities Trading Act, which is called the Wertpapierhandelsgesetz, WPHG. And in addition, there are a couple of low-level regulations, Rechtsverordnung and BaFin guidance available on the German regime. So this is a short overview about MiFID. Let's move over to the Switzerland. Of course, Switzerland is non-EU. So it does not have a MiFID regime, but it's still interesting to see how the financial regulation works there. And I'm happy to hand over to Dominik.
Yeah, Sebastian, thank you very much. Ladies and gentlemen, I would like to briefly state how it's going on in Switzerland with MiFID. As Sebastian said, we are not a member of the European Union. I'm sure you're aware of that. We have never been. We call this situation Swixit because it's kind of related to Brexit, but actually we did not exit. I mean, we have never entered. But the situation is kind of, most likely, we face the situation now, which maybe the UK will face later on after the Brexit. So MiFID is not applicable. And nevertheless, I think the crucial part for Switzerland is that MiFID has an important chapter on third-party access to the European Union market. And that's important for Swiss financial services providers, banks and fund managers and wealth managers and so on. And MiFID requires that third-party providers have an equivalent supervisory regime in order to get access. And the question is whether Switzerland has. And I think there is no doubt Switzerland does not have an equivalent system. Maybe some people consider the EU system as too high, but or too low or whatever, but at least Switzerland is definitely not on this level. So we had to kind of implement a MiFID regime, and we have done so. We are doing so with two new acts. One is called Financial Institutions Act, FIA, or FINIG, Finanzinfrastrukturgesetz, Institutionsgesetz, and the other is FSA, so the Financial Services Act, FIDLEG. And with these acts, we hope to be equivalent to the MiFID regime. Most likely, it's a nice try. Most likely, we are not equivalent. That's my view. I think, principally, there are two reasons. One is a legal reason. We have several areas which we do not regulate. This is cost transparency, for example. The whole regulation on retrocessions is much more lenient than on the MiFID. And the supervisory regime over the Swiss independent asset managers, this is also most likely not in line with what the European Union requires. So this is the legal analysis. At the same time, at least I myself think it's also a political question. These equivalency discussions, we know them from AFMD, third-party access. We know that ESMA has now decided 3 times that Switzerland would be equivalent, that Switzerland is equivalent, and the Euro Commission has still not granted access to the Swiss asset managers. And so that's the reason why I think it's a political decision, and most likely the European Commission will kind of hold the same position with regard to Switzerland when it comes to MiFID equivalence. So there is just no reason for them to give Switzerland access. Nevertheless, I mean, we have these acts. So Parliament has approved these 2 acts on the 15th of June, or 12th of June. We have now the referendum period, so we may have a vote on these 2 acts, most likely not. And we expect them to enter into force on the 1st of January 2020. With a transition period of 3 years, most likely. That would mean that they really become sharp on the 1st of January 2023. The crucial points will be regulated in ordinances. We expect there to be 5 ordinances, and they are currently being developed by Parliament and practitioners, but we have no indication yet. But I think what's important, I mean, we have 2 new laws which will come into force. They will come into force on the 1st of January 2020 and transition period till 2023.
Dominik, thank you very much. Could you elaborate a little bit, could you explain a bit more the third country access? If someone from, maybe you have a MiFID investment firm from Germany, is it easy to access Switzerland or is it difficult? How would this work?
Yeah, absolutely. I think I've briefly now talked about the third country access into the European Union, but I think it's an important question here. You're right, Sebastian. How is it about foreign companies coming into Switzerland? And the situation will be that either you are regulated, prudentially regulated outside Switzerland, and Equivalently, prudential regulator means you have kind of a BaFin license or an FCA license in the UK, and then you can come into Switzerland. In the case you do not have such a license, you can offer advisory services in Switzerland, just pure advisory services, and then you need to be registered in a Swiss register. That's how it stands in the law, and we will see in the Swiss ordinances there will be more details about that. But most likely it looks that the third-party access to Switzerland will be quite open. So it's definitely not as a hard system as we know it under MiFID. It will be a hard. We expect that all service providers from the European Union will get access into Switzerland.
It's interesting. Just one question on the requirement of the prudential regulation. I'm not quite sure if you know it. We have some firms here in Germany which are not regulated under MiFID, but under this MiFID exemption for some fund distributors. It is called, we are regulated under the Gewerbeordnung 34F, Finanzanlagenvermittler. And it is a kind of a regulation which is kind of similar like MiFID, but it's not the entire MiFID regime applicable. Would you think this would also suffice for prudential regulation? It's not a BaFin license, it's a local license.
No. Yeah, sure, we are familiar with that. I think this question started when we had the new Collective Investment Schemes Act in Switzerland, when there was kind of the route opening for foreign distributors to distribute funds in Switzerland. The opinion nowadays is that this Gewerbeordnung license, the 34, that this is sufficient for distributing funds, non-Swiss funds to qualified investors.
Okay,
and, we expect this to stay, to remain. So those who have this Gewerbeordnung license, we expect them to still have access to Switzerland.
Okay, thank you. And to make another distinction, the laws we just talked about apply to the kind of MiFID investment firms, to placement agent advisory firms. If you are a fund manager from Germany, you would like to market into Switzerland, these kind of laws do not apply. Is this correct?
Yeah, right. I mean, the situation will be similar as in the European Union, where you have MiFID for the non-collective asset management and UCITS and AFMD for the collective asset management. We will have these two acts, the Financial Services Act and Financial Institutions Act, for the non-collective investment management, and the CISA, Collective Investment Schemes Act, for the collective investment management. So if you have a non-Swiss asset manager, like let's say a German or UK asset manager who wants to distribute the funds into Switzerland, we will have on the one hand look at the fund, and on the other hand at the person. The person itself distributing funds will be considered like a advisory activity. So there we have to, they either need to be prudentially supervised, so BaFin license, or registered in Switzerland. And when it comes to the fund itself, if you want to distribute them to retail investors, then you need a UCITS fund, you can register. If not, then you're just limited to qualified investors.
Okay,
so this will not change. The whole fund distribution area will slightly change, but not much.
Okay, yeah, this was very interesting, at least to me. I hope it's the same to you. Please apologize if I ask a couple of technical questions here. But it's an interesting topic also for me, educational topic for me. And then let's switch over to the UK, to John. Please give us a short overview about the MiFID regime in the UK and how it is implemented there.
Sure. And I think we're just about good afternoon, everybody. Yes, as Sebastian has already said, MiFID 1 was implemented into the UK 10 years ago or so. MiFID 2 was implemented at the beginning of this year. It's been implemented through the key piece of legislation, the Financial Services 2000 Act. That is a primary source of regulation in terms of financial services in the UK. But the key provisions in relation to MiFID have also been implemented through what's called the FCA Handbook, which is at the end of the point there. And I think we'll get onto it subsequently, but there is some subtlety in terms of how the UK has implemented some of the provisions in under MiFID, in terms of, as Sebastian was saying, one of the key provisions is provision of services to clients, and the client definition is very much persons to whom investment firms are providing activities and services, rather than, say, an investor who is essentially considered to be a counterparty. And so I know that there's there are divergences in terms of how different member states have interpreted those kind of requirements, but in the UK there is a growing market practice, and the regulators sort of tacitly accept this by certain provisions in the FCA handbook, which means that some of the more onerous provisions don't really apply in the context of fund distribution, where you are marketing to a counterparty rather than if you've got an advisory arrangement or you're providing portfolio management services.
John, let's dwell on this a little bit, because this is a difference to the German view.
Well, I think obviously this is relevant for firms whose home member state regulator is the FCA, because obviously a German firm marketing into the UK or interacting with UK clients is subject to the home member state or its regulator, either BaFin. So it's their interpretation of the rules which is relevant. But for UK firms, there is the concept of a corporate finance contact, which is essentially a counterparty to whom you are marketing a product. So if you're marketing or distributing a fund, the placement agent or the firm itself would be making clear to the recipient of financial promotions, communications, that they are not a client, they don't have the same regulatory protections as a client would, and in that way some of the disclosures in terms of costs as well as aspects of product governance as well can be disapplied. And as I said, that's a nuance in terms of how the FCA have implemented MiFID II under the FCA handbook. And I think as a sort of a general thematic point, I think that's primarily because the FCA regulator doesn't feel that the same protections that should be provided to retail clients should be provided necessarily to professional clients. But still, that's where the key distinction comes in terms of the nuances there. But as I said, this is sort of more relevant for UK firms whose home member state is the FCA, not really for German or Austrian or anybody else marketing or working with UK clients, because it's the home member state rules that apply.
Yeah, this is totally different from in Germany. In Germany, if you market via placement agent fund interests to investors, then the client of the MiFID investment firm will be, of course, also the investor, and all the protection rules and the rules of good conduct apply to the relationship between the MiFID investment firm and the investor. And in the UK, at least in the area of professional and institutional clients, we are of the view that these kind of professional investors, institutional clients, are not clients of the MiFID investment firm. And as a result, the entire rules of good conduct do not apply to the relationship between the MiFID investment firm and the professional client. We talk about these kind of rules later on a little bit about it, but it's an important distinction which I never quite understand, but it's obviously a kind of a nice industry, private equity, nice view.
It's certainly welcome in the UK in terms of that distinction. And I think one of the confusion or the ambiguity comes by the concepts of, AIFMD, we refer to professional clients, but then professional investors. MiFID talks about professional clients, and it's the distinction between that terminology that has allowed for this interpretation.
Okay, yeah, thank you very much. Just one more question on the rules applicable in the UK. Whereas in addition of this kind of financial service markets act, there's in addition this kind of financial promotion order. What's this about?
Sure. And that's, and I think we'll come to that in maybe a few more slides from now, but that's something that's very relevant for German firms, which will be seeking to market both services and products to UK persons. The financial promotion order is something that dates back to 2001, so predates MiFID I, and essentially applies to anybody, wherever they are in the world, if they are communicating a financial promotion to a UK person, in short. So US, German, Swiss, Brazilian, wherever they are, if you are calling up somebody in the UK and saying, would you like to buy X fund or would you like to buy this share, then the financial promotion regime will apply. You don't need to be authorized or regulated. It's a separate regime from that. It's really about who you are communicating to and making sure that there is an exemption which applies. And it's slightly different from AIFMD marketing.
Okay.
Generally speaking, generally speaking, the financial promotion rule has quite lenient exemptions if you're marketing to institutional investors. High net worth companies are essentially entities which have got net assets of £5 million or more, and trusts it's £10 million. Where the complication comes is, to get to make sure you comply, there's a rubric that would be included in the PPM or the presentation. Where the complication lies is if you're trying to market a product or communicate to natural persons, individual investors, whether the exemptions are slightly more nuanced and more detailed, or to trading companies that are very small. But generally, it is something that needs to be considered, and we'll come onto this in the context of German AFIMs wanting to market and whether or not they're sub-threshold or full scope. But that's the key definition. As Sebastian said, it's something to always remember about, but generally if you're marketing to UK institutional investors, you shouldn't really have an issue. There's a rubric that would go on your communications, but it should be okay.
Okay, thank you very much. For me, it's important to understand it's a different regime from MiFID, and it applies in parallel or instead of MiFID to certain activities. Okay, I think now we have got a clearer picture of the regulatory regimes in the different countries. Now let's move to a more specific case. This is unfortunately the wrong slide here. So let's look at we have a certain case before our eyes, which means we have a German sub-threshold manager, small registered manager, who wants to market from Germany into the UK, into the Switzerland, and maybe would like to engage a placement agent. And so we will discuss a little bit what kind of rules apply in this context. MiFID is also relevant, as I also already mentioned, to advisory mandates. If you have a relationship with someone, with an institutional investor, insurance company, and you advise this company on kind of investments in private equity, then it's an advisory mandate, and you are regulated by MiFID. And it also applies to managed accounts. If you provide portfolio management services to an institutional client, then it's also a MiFID-related activity, as long as it's not a fund-related activity. And what we do not talk about is we will focus on this case study that we have a German sub-threshold manager who wants to market into the UK or into Switzerland and might engage a placement agent. And to start it, I switch over to Dominik, who will talk a little bit about distribution regime in Switzerland from a German perspective, but with a view on the Swiss regulations.
Mm-hmm. Yeah, thank you. I mean, we somehow come back now to what I've said before. In this case, as Sebastian said, we have a non-Swiss fund managed by a non-Swiss manager, and it should be distributed into Switzerland. If the non-Swiss manager itself distributes, to the extent it has a BaFin license, he may do so. So the activity himself of distributing the fund, that's legal. He can come into Switzerland. The question currently is to whom does he want to distribute the fund? Of course, if he wants to go into the retail area, then it's just a usage question, but I think that's not the topic here. If he wants to go to if it's an alternative fund, then he may have to appoint a representative and a paying agent. And this will change in the future. With the new regime, with the new 2 acts, so starting from 1st of January 2020, he will, in absolutely most cases, not need to have a representative and a paying agent anymore. This is somehow weird. We have implemented this representative and paying agent for the alternative funds in 2013 in order to become AFMD equivalent. Now, as I said, ESMA has ruled 3 times that we are equivalent, and now we kind of give up this representative. Whether we still will be equivalent even without a representative or not, that may be seen, but I think it was not a wise decision of Switzerland to give up such an aspect, because it would be a good reason for ESMA then to say, oh, look, now you even give it up equivalence yourself. But as I said, in the future, no representative, no paying agent anymore for distribution.
This started 2020?
This will start most likely 2020.
Okay.
Yeah, this will start most likely 2020. Now, with regard to the placement agent, if they want to appoint a placement agent, these are usually not regulated, so they have no regulation. For them, they will have to register in Switzerland with a register of client advisors, how we would call them. They need to prove that they have a certain experience and academic background for the products which they distribute. And if they are registered, then they can actually distribute the funds again to their target investors. So there will actually be an extremely small change only. from a regulatory point of view in the future. I think it's important to know that as it looks like that no more representative and no more paying agent will be necessary from the 1st of January 2020 on.
Which I think is a good thing from a German point of view, because we always wondered what these kind of people are doing for their money. Just to question.
Yeah, I think that the point really is, you're right. I mean, these representatives are extremely expensive, and of course they have a certain liability. You just pay the liability, which they have. They don't do much, so it's really just liability which you pay. That's finally paid by the performance. Of course, the fees are paid by the fund. So I think you're absolutely right. These representatives don't make much sense, but I think we have to bear in mind that under AFMD, this legal representative has just been introduced. The gesetzliche Vertreter has just been introduced. So I don't understand why we give up something which has just been introduced in the European Union, as long as we are discussing whether we are equivalent or not.
Of course.
I think that's the trigger point where they should have thought a little bit more about it.
Yeah, thank you very much. It was interesting to get this view here. An update on the Swiss side as well. I didn't know about that the regime is going to change in the future. So then let's hand over to John to talk a little bit about fundraising regime in the UK. Again, from the perspective of a German fund manager who would like to approach someone in the UK. With as few regulations as possible.
Yes. So just sort of taking the different points. So what I've done is said, if you're a full scope authorized German AFIM and you want to be marketing a product into the UK, you obviously have to at some point apply for the AIFMD marketing passport. Similar, I think, to Germany, there is quite a liberal interpretation of pre-marketing. So if you're a full-scope German AFIM, you can actually engage in discussions, talk about the product, provide draft documentation to the potential investor before you actually need to have got your marketing approval. So that's quite a good characteristic of the UK regime. But it is the case that you would need to be obtaining marketing approval at the appropriate time. As Sebastian touched on before, there's also the financial promotion regime, which sort of sits side by side, the AIFMD marketing regime. The key point there really is that, as I said before, if you're marketing to institutional UK investors, that shouldn't be an issue because there's a rubric and you're fine. So that's German managers and similar kind of points that would need to be established or thought about if a placement agent is appointed by the German manager, because they would need to be thinking, as an agent, they need to make sure they're not marketing the fund. So similar kind of restrictions would need to be thought through. If you're a sub-threshold German manager, which as I understand it, there are more sub-threshold German AIFMs than full-scope AFIMs, the UK regime is actually pretty positive, or certainly liberal, in the sense that you don't need to get a marketing approval at all. So AIFMD, there is no requirement if you're a sub-threshold European AFIM to obtain any kind of marketing approval. So the fallback is you need to have obtained or not obtained, you need to comply with the financial promotion regime. So if you're a sub-threshold German manager and you are wanting to raise capital from institutional UK investors, you essentially should include a rubric to the effect that you're only marketing to exempt persons under the financial promotion order, and as long as you've got that, you're essentially good to go, and there's no requirement for compliance with AIFMD from a UK perspective, or requirement for registration of fund marketing.
To whom can you market under this financial promotion regime? What kind of...
So as I said, it's institutional investors, which is high net worth companies. It's actually got quite a liberal or low threshold. We're talking about 5 million in net assets. If it's a trust or a family office, 10 million of net assets. So where it becomes complicated is if you're marketing to individual investors, or as we've got on the bottom side, not only are there more requirements in terms of the exemptions and complying with an exemption, but obviously we've got the PRIPS regulation now that means that if you're marketing to a retail investor, there are certain obligations that are triggered. So that's the fourth point. In terms of the third point on the slide, there is this concept of arranging activities. So going back to what we were discussing before about MiFID and the UK regime, essentially, and I won't bore you by going into all the details, but you have MiFID was transposed within an existing financial services piece of legislation, which refers to regulated activities. Most of the MiFID activities neatly fit within within one of the regulated activities, investment advice, portfolio management, for example. But there is this concept in the UK of arranging deals being a regulated activity. So if you're arranging deals and investments or making arrangements with a view to transaction investments, that can be a regulated activity. If you are a German manager or placement agent, it shouldn't be the case that as long as your activities are predominantly outside of the UK, and maybe you're flying in and flying out and having communications with people, that wouldn't be sufficient in terms of the nexus in the UK to be constituting arranging activities, but is something that one should bear in mind. If, for example, you were to set up a representative office or to have a person at your firm basically work out of a hotel or a temporary office for a number of weeks or months and be passing business cards around with a UK number on it, then that's far more likely to actually be potentially within the net of regulation, and then one needs to check, is that he or she doing more than just financially promoting? Is there actually arranging deals going on? And then you would potentially need to be regulated, and that would often be regulation under the UK regime as needing to establish a UK established firm, essentially. But overall, I think it's, especially for sub-threshold managers from Germany, it is quite a liberal regime.
Okay, and John, if you were as German sub-threshold manager, you would market to retail clients from Germany into the UK, would this be considered arranging of deals, or is this just...
No, I don't think it would be. I don't think it would be.
This would be a different thing under the financial promotion regime, correct?
Yes. Okay. So you've got the regulated activities regime and you've got financial promotion regime. And financial promotion is for anybody anywhere in the world communicating with somebody in the UK. And then you've got regulated activities, which is regulated activities carried on by business in the UK. Okay. And it's the in the UK, which is, it's not a clear line, but it is something that I think if you're outside and you're interacting on occasional basis with UK investors, then that shouldn't be enough to be constituting arranging. But it is, it's something worth thinking about, especially if you actually have somebody spending a lot of time in the UK. Then it's going to become far more acute as a determination.
Maybe let's hand over to Dominik with regard to the connections to Switzerland. If you are a German manager and you phone someone up in Switzerland, or you're a German placement agent, you phone someone up, is this already under the jurisdiction of Switzerland? Or do you have to actually have presence in Switzerland to become regulated?
Mm-hmm. Yeah, I mean, I think that's a very good question. But on the institutional side, that's considered a regulatory relevant activity in Switzerland. So if you distribute into Switzerland, if you call from Munich into Switzerland, that's an activity which falls under Swiss law, even if you do not travel to Switzerland. In addition, it will be even more applicable if you do travel to Switzerland. But that's, as I said, an activity which falls under Swiss regulatory law, and there either you are prudentially supervised or you need to be registered with this famous register, which will be implemented then from the 1st of January on.
And is there a kind of reverse solicitation concept available? For instance, if the Swiss investor sees that someone interesting fund manager from Munich and calls the Munich fund manager, would this also be caught, or would this be outside?
Yeah, I think reverse solicitation is always a hot topic, and it's good you raise it. I think the question is the same as it is in the European Union. Of course, we will still have the reverse solicitation system as much as it is also foreseen in MiFID and UCITS and the AFMD. The question is, what is reverse solicitation? I think the Swiss understanding is the same as it is in the European Union. Reverse solicitation requires that really the very, very first contact has to be done by the investor. And if you start, I mean, these famous emails, please send me an email saying that you want to have some information on my bond fund or on my private equity fund, then it's not reverse solicitation anymore. I think the problem, what I see is not only in Switzerland but also in the European Union when it comes to these big private equity houses which raise a fund every year. And where the investors know that they have a fund, let's say fund number 1 has been raised in 2010 and fund number 2 in 2011 and fund number 3 in 2012 and surprise, surprise, fund number 4 in 2013. Then you have your investors and they know that you will launch a new fund every year and it may well be that there is 1 year where you have sufficient funds raised just by your existing clients because they know that you will raise a new fund. And I think these are the topics where I see where you have a problem, that it may very well be that you have a complete fund raised by reverse solicitation, because your clients know that you will have a fund, because everybody knows that you will launch a new fund. And the understanding what we see from FINMA is that reverse solicitation cannot be a business model. It cannot be. So they really will have, you have very good, you need to have very, very good evidence that the fund has been raised completely by reverse solicitation only, and they will question that. And we have seen cases where FINMA investigated these cases, and they really wanted to see. And at the end, it was interesting that even when I talked to the client, it was actually a good client, but at the end, it turned out that there have been some of the investors have themselves not confirmed anymore that it was reverse solicitation. So I think if you want to go the reverse solicitation rule, you have to be really, really sure that it is a reverse solicitation.
Yeah, I think we have the same view actually in Germany on reverse solicitation. It's very strict. John, what about the UK view on reverse solicitation? If you have an individual in London would like to invest into a sub-threshold managed fund here and who does not qualify under one of these exemptions under the financial promotion regime, can this be a reverse solicitation solution?
Not, as I said, reverse solicitation is more of a concept in terms of whether or not you're falling within the scope of AIF&D marketing, whereas you still need to be thinking about financial promotion regime. It's completely sort of separate, albeit very much similar sort of crossovers. I mean, in terms of reverse solicitation under AIFMD, without wanting to represent the UK as some kind of offshore liberal regime, there is some quite helpful guidance to actually allow, or at least create an argument to say that initial discussions potentially could be permitted, and then you can still rely on reverse solicitation. That's on the basis of FCA guidance, but that's caveated by you shouldn't be using it as a way of contravening the AIFMD. So it's still a grey area, but if it can be relied on, and often, I mean, I advise UK clients, but I often advise a lot of our US clients, and they'll often want to know about reverse solicitation because obviously it's far more favourable to be able to rely on it than not. And often for them it is, they will have an existing relationship, and often they just want to know, has anybody ever been, taken to jail with it? Has anybody been fined? Is there an enforcement? What are the risks? And there is an inherent risk with relying on reverse solicitation, both for an investor complaining or a regulator finding out. But I think that, it's certainly my experience. I absolutely agree with Dominik and Sebastian in the sense that it's not a strategy. It's generally something that happens to you rather than something that you create. But it is still something that is being relied on, just because I think for a US manager, for example, managing into some European jurisdictions, it's just not possible to have a marketing approval. So it's sort of the only show in town.
Dominik, you would like to add
something?
Yeah,
I think it was a very interesting point which John raised. I mean, and if you do reverse solicitation, or if you have unallowed reverse solicitation, so and what's then? I mean, it was the consequence. We have seen in Switzerland that the consequence was minor. We got a strongly worded letter by FINMA, and of course the client could live with that. As a fund manager, you know that do not only get love letters from the regulator. So, I mean, that was okay. We have seen it once in Greece. We had a huge investigation by the regulator in Greece, and at the end, the client was fined by €5,000. Was a little bit disappointing for the whole work they did. Only a fine of that 5,000. I do not know. Maybe it would be interesting to see. I mean, what is your experience also in the audience? What can happen on the one hand side? Maybe on a criminal level, can they be gone to jail or be fined? What has the regulator done? And maybe in addition then, if you violate the distribution rules, can an investor, let's assume that the fund goes south, can you then actually kind of a claim against or claim for damages because you had been subscribed for by the fund in a non-legal way? Yeah, I think that's the question. What remedies has the investor or the regulator, and what can happen? Because if nothing happens, then you can run the risk.
Yeah, under German law, the investor would certainly have a claim against the fund manager for illegal marketing and would be able to get the money back. This would certainly be the case. I think this is the highest risk of reverse solicitation. You wouldn't face any risk from the regulator. This would not be the biggest risk. The biggest risk is indeed that the investor can get the money back if the fund goes south.
Even institutional investors, even in institutional, I mean, smart guys, they could say, we have seen all documents, we have been aware of everything, but just the reason that distribution has been done in violation, they could claim back for damages. In Switzerland,
No?
I cannot imagine that would be possible.
Now, I think in Germany I could imagine this very well. I mean, if such a case becomes to a court here in Munich and the people just read the law and then they say, "Oh, sorry, this was against violating the marketing rules," and then you are done. I think this will be a pretty short discussion.
How would that be in the UK? I mean, would an investor have a claim against?
I mean, potentially, you know, breaching the financial promotion rules that we talked about is technically a criminal offence, and you know there is a rescission right if there are communication made as a result of non-reverse solicitation versus a true reverse solicitation. So there is that inherent risk. I can't recall there ever actually being a claim or the regulator enforcing against it, and I think in terms of the general regulator's view, they're much keener to protect retail investors. So this is more acute if somebody is going around trying to promote a very technical hedge fund to widows and orphans in the UK, then the regulator would be far more interested. If you're dealing with very large investment managers in the UK that sort of know the game, so to speak, in terms of reverse solicitation, then I think the FCA would not really be interested in protecting them if they were subsequently bring a claim. That doesn't mean they couldn't bring a private claim in the court and argue that actually the contract was void because there wasn't true reverse solicitation. But to me, I'm always because reverse solicitation is so much based on the underlying facts, and you could always argue that X phoned up Y and vice versa, and it's almost how can you prove it either way? I know that there's a sort of onus on to evidence that there was reverse solicitation, but similarly, if you actually went to a court of law, I think there would still be a requirement to actually show that there wasn't as well. So it's still something that is a grey area. Some people use it more liberally, I think, than others, but there is always a risk.
Okay, thank you very much. So let's stop this topic here and move on and speed things a little bit up. We have about 5 minutes. The next slides are basically, the next 2 slides or 3 slides are basically there to give you some awareness. We will not discuss this in detail. One important change of MiFID II is that you have to provide certain disclosures of costs and charges. And this only applies if you engage as a fund manager a placement agent. The placement agent then is required to provide the investor with a template which discloses the cost of the financial instrument and the cost of the financial service, which is the cost of the placement services. And with regard to the costs of the financial instruments, here it becomes interesting. The ESMA says that you can refer to the calculations under the so-called PREPS key investor document, which is very difficult calculation to make, but you can apply the same calculation methods. And in this area, the PREPS kit becomes relevant for the MiFID cost and charges disclosures. And one important point here is if you marketing a fund via a placement agent to professional investors, these kind of costs and charges disclosures also apply. This can only to a very limited extent be waived by the professional investor. So this is important new regulation, and this will come back also to the fund manager, because the fund manager will have to provide all the calculations on the costs of the financial instruments. So this is a kind of an indirect way where for fund managers MiFID II becomes applicable and the PRIPS regulation becomes applicable for fund managers even if we distribute only to professional investors. So this is just an important thing to keep in mind. And the next thing also is a slide to keep in mind for fund managers who would like to engage a placement agent. It's about what are the requirements on marketing materials in MiFID. This has become relevant because MiFID now also applies these kind of requirements to professional investors. In the past, these requirements only applied to retail investors. Now they are also applied to professional investors. And what you often have in marketing materials sent out by placement agents is kind of a nice presentations with past performance. The past performance always looks great. You get IRRs of 20% plus, and you get past performance from the last 2, 3, 5, 6 funds, and with great numbers. And under MiFID II, these past performance indication starters need to comply with certain requirements. For instance, you have to provide at least 5-year periods. So you cannot aggregate numbers. You cannot say the last 3 funds, or we got an IRR since 1982 of 20 plus. you cannot aggregate these numbers. You have to break down the numbers in at least over 5 years, and you have to break down the numbers for complete 12-month periods. So you cannot aggregate the number over 10 years. You have to show down the development, the IRR, in each of the 12-month periods in your presentation. And what's also no longer possible, what you often see, you see a nice presentation with lots of benefits, how good the fund is and how good the investment is, and then on the last page you see in the fund print 2 pages of risks for the investor. This is no longer possible. Now there must be a benefits-risk balance. If you mention benefits, you also need to mention risks in a kind of the same way. And also, and this is important, in the same font size, in the same layout. So this is something you also have to keep in mind. And this also applies to presentation you hand out as a placement agent to professional investors, to professional clients.
And I'll just add to say what we were talking about before. Fortunately, from my perspective, the UK has taken a slightly different approach in terms of fundraising, in the sense that these are applicable where you're an advisor or a manager marketing to a person to whom you're providing services, whereas an investor doesn't fall within that category. And so under the UK regime and UK placement agents as well, don't strictly need to comply with these. Some are good requirements in terms of highlighting risks as well as benefits, but fortunately the UK is slightly different interpretation.
Yeah, but of course, yes, of course. But of course, where it becomes relevant is if you have a PPM, private placement memorandum, developed by the fund manager, and in the PPM, we are of course also often performance figures, performance data, and in 100% of the cases, the performance data does not comply with the MiFID requirements. For instance, it is not broken down in 12-year periods, or it provides data on gross IRR, and it does not provide how net IRR would change the IRR data. So this is something you have to keep in mind as a fund manager. If you provide marketing materials, or if you create a PPM with a business part in it, with nice figures in it, you have to keep in mind that you have to break down performance data into 12 years periods, and you have to provide net figures. Or if you provide gross IRR, you need to mention how net IRR would have been if all the costs and charges of the financial instruments of the fund, like management fee, like carry, would have to be included in this figure you provide. So this is important to remember for fund managers. And so now maybe we should, would it be okay, Dominik, if we skip the marketing materials slide on the Switzerland, or we maybe say 2 or 3 sentences to the marketing requirements on the materials for Switzerland?
Yeah, I mean, it won't change much. When it relates to funds, then we have to disclose these 4 traditional points: the country of origin of the fund, the Swiss rep, Swiss paying agent, the place where the documents can be obtained free of charge. From 2020 on, when this representative requirement will be given up, most likely then we won't need to have point 2 and 3 anymore. When it comes to non-fund, so to the direct asset management, like mandates, then marketing materials just need to be transparent and need to be disclosed as such, so that people know that this is a marketing material and not, let's say, a contract or so. So the requirements are much lower than on the MiFID. I think that's what we see. And then I come back to the point where I said at the beginning, it's very questionable whether the Swiss rules are equivalent to MiFID. So I have my doubts. And in particular, cost transparency and all this stuff, we are not so detailed. We just say it needs to be transparent, and you need to know what it will cost, of course, but there are not these technical descriptions of what you need to disclose and how often you need to redisclose. And all this.
Which is the right approach, I think, but it's now the way it is here. Unfortunately. I think that's it. Thank you very much. We have a couple of leftover topics, but in the interest of saving time, we do not discuss. Thank you very much for joining us and staying with us, and hope you still enjoy your day here in Munich. Thanks.